Good evening, everybody. My name is Larry Sager. I'm the Dean of the Law School here at the University of Texas. This is a very important and attractive occasion from the standpoint of the law school. That's so for a number of reasons, but they combine to make my welcome especially heartfelt. One is that today's panel, which is billed as a dialogue on the law and policy of detention and counterterrorism, is the product of the Strauss Center. And the Strauss Center, in turn, is one of a number of instances of the growing and fruitful cooperation between the School of Law and the LBJ School. So it's wonderful when we do things together. We have a kind of rich menu going forward of cooperative agreements, and the Strauss Center is a wonderful instance of those agreements and is ably headed by and represented here by Professor Jim Lindsay, who's in the back of the room. So an important part of what makes this attractive is the authorship of it. More precisely, the animating intelligence of this panel, and the person who will introduce the other panelists and guide them and you through this conversation, is Professor Bobby Chesney, Robert Chesney more proper. But Bobby, as he is known to all of us, is a visiting professor at the law school this year, is a fellow of the Strauss Center, and is a nationally and probably worldly renowned expert on the topics of the evening. He has written about and spoken about these events at great length, and part of his very attractive professional portfolio is manifest in, or will be manifest in this conversation. The third reason that I'm especially pleased that this event is taking place is obviously the issues are so important and so intractable. One might suppose superficially that they would simply vanish with the changing of national executives, an executive order which has already stipulated the relatively proximate closing of the Guantanamo detention facility. But I actually think that the issues that we are talking about are not likely to vanish at all. And indeed, they may become much more important and much more difficult. There's a variation, and I don't want to take up much time, so I won't wax on this at length. There's a kind of variation on the despair of the nighttime English talk show hosts that they've lost an important source of their humor with the changing of the presidency. There's a variation on that holds with these issues, I think, which is during the tumultuous events of the past administration, in some way the constitutional issues were made easier. And they were made easier because the administration, which is now left, tended to take very extreme positions on questions. And the court tended to respond by repudiating those extreme positions. But there is a great deal of space between the positions often taken by the Bush administration and on some important occasions repudiated by the Supreme Court and the questions which will now come up. It isn't the case that the changing of national administrations will eliminate the problems of counterterrorism, will eliminate the incredibly complex issues of the relationship between Congress, the court, and the executive on these issues. And they may grow more subtle and all the more important to talk about. Some measure of how widespread and important these issues have become. Well, let me just state the other set of issues. The other set of issues about which the same can be said is that this is an area of law and policy where international law and international diplomacy intersect with domestic law and domestic events in an extremely complicated way. So in some ways, we may have seen the easier questions resolved to this point, and the hard ones may begin. Some measure of just how pervasive these questions have become is that we all couldn't but notice that there was at least the segment of a Boy Scout troop in the audience today, which led me to wonder if that we were now going to have a counterterrorism merit badge. But you are entirely welcome, and I'm delighted to see all of you. And without further ado, I want to introduce you to Bobby Chesney, who I've already told you about, who will guide us through the proceedings from here. Welcome to you all.
Thank you very much, Dean Sager, and I'd like to also say thanks to Jim Lindsay for having the foresight to call for an event of this type to take place on the heels of the inauguration. It was inspired to suggest it, and I was very pleased we were able to pull it together. I'll begin with a few remarks about the issue and introduce our guests before highlighting exactly what sort of format we'll be using tonight. I'll begin by noting that the United States is at a crossroads. For more than 7 years, we've struggled to define a counterterrorism policy that is effective, that is politically sustainable, and that simultaneously reflects our core values, our ethos as Americans. And we've not yet succeeded at doing this. For more than 7 years, we've been living with a debate on counterterrorism law and policy. All too often it's been characterized by polarization and partisanship, by a mutual failure to link legal policy to a clear-eyed assessment of our long-term strategic interests, and by a profound lack of imagination in seeking to overcome the many false dichotomies that tend to be raised by this debate. None of that is true of the individuals we are fortunate enough to have here tonight as our guests. They do hold very divergent opinions, but they have in common an interest in shifting the law and policy of counterterrorism, especially that relating to detention policy, onto wiser and more defensible grounds. One of them is not here with us. As we all know, there has been terrible weather in D.C. The ice storm has caused all of our guests' flights to be delayed. One is en route to the law school now and will soon be sliding onto the end of the table without any of us noticing. But let's talk about him while he's not here, and let's say nice things about him. Benjamin Wittes, of the Brookings Institute, where he's a senior fellow, formerly of the Washington Post editorial board. Perhaps most notably for present purposes is the author of a much deservedly acclaimed book, Law and the Long War. And if you were to be looking for a single volume that you would buy in order to really plumb the depths of why these issues, as the dean said, tend to be intractable across a range of subtopics, this is the book to get. I assign it to the students in my seminar. I strongly recommend it to you. Ben is unmatched in his even-handed insight, not to mention the articulateness with which he writes. Speaking of articulate, Steve Vladeck, who is here with us. Steve is both a close friend of mine and a professor of law at American University's Washington College of Law. Among many other distinguishing features, Steve is notable for having served as part of the legal team that prevailed in the Supreme Court in 2006 in the litigation Hamdan v. Rumsfeld that ultimately struck down the military commission structure as it was then constituted. Steve writes extensively and insightfully on a range of post-9/11 issues, often concentrating on the particularly thorny questions that arise when these issues arise in a judicial setting. Finally, we're lucky to have with us John Bellinger. John has just completed a remarkable 8-year term in public service. John was the legal advisor to the National Security Council from before 9/11 through early 2005. And from that time until just last week, he was the legal advisor to Secretary of State Rice. Now, we may never know all the details of John's government service, unless, of course, he happens to be working on a tell-all memoir, which would be awesome if you are, and I'd be the first to buy it. But assuming that's not the case, we'll have to rest on this. We know enough from various sources to know that John was routinely a source of reason and good counsel in heated debates where his counsel wasn't always heated, but we're fortunate that it was heard, and we're lucky to have him here with us tonight. He was often there to say things that were difficult to say, and to argue for a course that was, I guess you would say, the true lawyer's course, the true lawyer's perspective in the best sense of that phrase. Now, in light of these introductions, we're well armed to take up the battery of questions and issues that are raised by Guantanamo and the larger question of detainee policy in connection with terrorism and non-state actors, and indeed other issues of irregular warfare that have presented in the past 7 years. These questions obviously could not be more timely. What I'm going to do now is bring us up to speed in an extremely cursory fashion, hitting some of the highlights to make sure we have a common foundation for our discussion going forward, and then we'll launch into things. There are, according to Ben Wittes' incredibly accurate and informative account that you can download off the Brookings Institute website, there are exactly 242 detainees currently at Guantanamo. There's one further military detainee who's in the United States itself. That's Ali Salakale El-Mari, a resident of Qatar, who's been held as an enemy combatant in the U.S. for a number of years. There are more than 600 detainees in military custody at Bagram Air Base in Afghanistan. And of course, there are more than 10,000 military detainees in Iraq. Now, I'm going to bracket and set aside the Iraq detainees, perhaps unfairly, but largely on the ground that we've recently reached a new status of forces agreement with the Iraqi government that, among other things, calls for the gradual month-by-month transfer of that detainee population into Iraqi custody. We could have a whole separate panel on that topic, but we're going to bracket it and set it aside. As for Guantanamo, perhaps the most important thing to note is the fact that last summer, a much heralded in some quarters and much criticized in other quarters decision of the Supreme Court, Boumediene v. Bush, held that the Guantanamo detainees have a constitutional right to habeas corpus review, the legality of their detention in federal court. And those detention reviews have been proceeding apace since then. They're before a number of different judges in D.C., some proceeding faster than others. A few have already reached the merits. Judge Richard Leon has already decided the merits of several of these cases involving a not small number of detainees. He has determined that there is insufficient evidence to hold some of them and has ordered their release. He's determined that others are properly held, that there is sufficient evidence to justify their military detention, and they're held on that basis. So that process is going forward in producing results. Meanwhile, what about that one detainee held in America, El-Mari? His case, his habeas petition, it's before the Supreme Court as we speak. His petitioner's brief has been filed. The government's petitioner's brief was due this month. They've got an extension. Whether it'll ever be filed and whether that case will go forward remains to be determined. As for the Bagram detainees, an attempt to extend the Boumediene decision, that is to say to extend the constitutional right to seek habeas review of the legality of their detention, that's pending in district court in D.C. as we speak. It's been argued before Judge Bates there, and the decision may or may not issue. We'll wait and see what happens there. As you might guess from what I've described, all of these cases, all of these issues are subject to the control of a litigation calendar in every instance. There is a litigation docket that is rolling forward, grinding forward. The government can seek delays. The president can ask for more time to align litigation strategy to the long-term administration policy. But there's only going to be so many extensions. It's quite clear at this point that there will not be as much time as the new administration would like in order to hash out exactly what detention policy is going to be. The executive orders that President Obama issued last week, to much fanfare that the dean adverted to, among other things, call for cabinet-level task forces to both look at the particular situation of Guantanamo detainees and to decide what the larger detention policy ought to be going forward, among other things. And it gave them 6 months to do this. They don't have 6 months. They're not going to get 6 months. The litigation calendars in these cases will compel them to take positions on these hard issues sooner than that. Those task forces must work very fast indeed. So, legal policy will soon be made. Our goal tonight is to see if we can generate any wisdom about these hard issues. We are well situated to do it, given the guests that we've got. Here's how we're going to do it. Rather than the traditional format of having set-piece presentations, one at a time, seriatim presentations of 20 minutes apiece, we will have a moderated dialogue and the panelists and I have been talking about in advance what topics make the most sense to address. I'm going to strive for the most conversational exchange we can generate, because therein lies wisdom. And I'm pleased to see that Ben has arrived fresh from the airport. We're very pleased to see you. As the convener and moderator, I'm very pleased to see you. Thank you. The moderated dialogue.
What were you saying about Ben and that
he really
episode?
Is wonderful.
Yeah.
Of course, it's all recorded, so he'll be able to look back and see if we said nice things or not. Of course, they were all nice. We'll have this moderated dialogue. I will try to save about 25 to 30 minutes towards the end to take your questions. We want to extend the conversation at that point to you. When we get to that point, time will be of the essence. We'll make a deal. We'll keep our responses quick. You keep your questions, and make them questions. Keep your questions quick, and we'll all learn a great deal. And then, of course, there will be a reception in the atrium afterwards. Please stick around for that so you can interact with one another and the panelists. Now, without further ado, I'm going to move from the podium down to the table, and that's where the action will be going forward. Okay. Let me start with the question directed to John. And this has to do with the obstacles to repatriation. Here's the context of the question. The President's orders last week about Guantanamo closure and detention policy more generally, but especially Guantanamo, highlight the possibility that increasing numbers of detainees could be repatriated to their countries of origin or perhaps to other countries. And it's clear that not only has repatriation played a significant role in Guantanamo policy all along, but it's going to play an enhanced role perhaps going forward. There are catches, or there are problems with this, or so it is said. One type of problem would be, you might describe the security problem, the possibility that someone will be repatriated and released, only it will turn out that that was someone who was dangerous, an al-Qaeda member perhaps, should have held on to them. A possibility highlighted by the series of New York Times stories this week emphasizing that a pair of former Guantanamo detainees have turned up in Yemen proclaiming themselves as al-Qaeda members. Indeed, one is a leadership figure there. Separately, there's the risk to the detainees themselves, that if we do send them back to their country of origin, perhaps they may be abused or tortured there. It's certainly a concern. You've had a lot of experience, I think, grappling with these problems in recent years. Can you tell us about that experience and what you perceive to be both the biggest obstacles and address the question of whether it might be different for the new administration?
Great. Well, thanks, Bobby. It's nice to be here. I see, let me start with two quick things. One, I see that although they say in Washington that Texas is a different country, I see that one thing is the same. When people come into a room, they start in the back and don't come to the front, which is just the way we have it in our staff meetings at the State Department, that everyone starts in the back and filters to the front. So I can't stand to see all these people holding up the back wall with all these seats empty in the front. So at least from my perspective, the host prerogative, I encourage you to come up closer and shoot questions at us. Second, while I have not yet begun my tell-all book, and I'm not sure there is going to be one after 8 years, although I've been in a lot of battles over these intractable issues, I will start with saying something publicly that I've never been able to say publicly in 4 years, although a lot of people have suspected it, which is that I have, at least for 5 years, supported strongly inside the councils of Washington the closure of Guantanamo, and have felt that very strongly. When I was Secretary Rice's transition manager in 2004 when we moved from the NSC to the White House, and one of the papers I wrote for her was that we really needed to resolve all of these detainee issues, which at that point were already an albatross around our neck, and I thought we needed to move to closure of Guantanamo. Guantanamo had a benefit. We can get into the benefits at the time. A lot of people seem to think that it should have been clear in 2002 that it was the wrong decision. I don't think it necessarily was. But by 2004, the damage to the country, at least that I saw and others saw, I think outweighed the benefits. So you may wonder, why do I say that up front? I say that up front because in hundreds of discussions with, at least with European audiences, when I try to answer questions and explain Guantanamo to them, when I can't say that I favor closure of Guantanamo, they tune out everything else that I say about the difficulties of closing Guantanamo and focus only on trying to convince me that Guantanamo has to be closed. So wherever you are on the spectrum, I just want to say that's where I'm coming from on that. But now I'm going to talk about the difficulties that Bobby alluded to. For the last 6 years, we really have been in the gradual process of closing Guantanamo. We started with 770 detainees in Guantanamo. We have repatriated to their home countries or to other countries about 500 people. We're now down to about 240. It's been an extremely difficult process because unlike a normal war, and one of the things that we need to talk about is just how this conflict with al-Qaeda is different from a normal conflict. In a normal conflict, you basically send everybody back to one country, or maybe one or two countries. In Guantanamo, we have people from nearly 36 countries, and we have had to negotiate the return to each of those countries of their nationals. So when people have said for a long time, including Europeans and others who regularly say Guantanamo must be closed, the assumption seems to be that we could just sort of snap our fingers and that it will be closed and that people will go home. In most of these cases, their countries don't want them back. They see them as troublemakers. They don't want them back. Or, as Bobby alluded to, they want them back and they may be willing to have them back, but we're concerned about their mistreatment. So for the last 5 years, and unfortunately from my perspective we were not able to close Guantanamo on our watch, we have reduced the population by about 500 through extremely arduous negotiations with more than 24 countries. And those have really gotten down into the 2 points that Bobby's raised. One, the concern that if people are returned to a country, that they will not pose a threat again. And in that regard, virtually no countries have been able to either detain or prosecute the individuals that we return to them. Only 2 or 3 countries with respect to detainees who we have returned to their countries have detained or prosecuted them. Now, their lawyers and other critics have been quick to say, well, that proves then that they did nothing wrong, because if they had done nothing wrong, then obviously they would end up being detained or prosecuted in their own countries. Well, not really so fast. And this is the same problem in this country. There have to actually have been criminal laws on the books for them to be prosecuted. And in many other countries, as in our own countries, there were actually not criminal laws that criminalize the movement of their nationals to Afghanistan to train. So with all but a handful of cases, the individuals who we have returned to different countries have been only briefly detained and often released. Now, we have have reason to believe, according to Defense Department information, that of the 500 that we have returned, about 60 of those have returned to the fight. And as Bobby alluded to, 2 who had been returned to Saudi Arabia have in fact emerged now as leaders of al-Qaeda in Yemen. And so this is a great concern to our Defense Department, and it really gets into sort of Washington bureaucratic politics are people going to be willing to let people go if they're going to be back to killing soldiers? Now, the other concern that the Obama administration, I think, is going to have particular difficulty with, and that has really bedeviled us, is that we don't want to return people to countries where they're going to be mistreated, because we have general legal obligations to not return people if we believe that there is a substantial ground to believe that they're going to be tortured in the country that they came from. Almost all of the individuals in Guantanamo came from countries with bad human rights records. So we have had extremely difficult negotiations to get assurances that if they go back, that they will not be mistreated. So that's been a real obstacle to getting people back. And in some cases, like a group that we will talk about of Chinese called the Weigers, we've simply decided we can't send them back to China because they would be tortured if they sent back to China. So for the last 5 or 6 years, we've been looking for some other country who will take them and haven't been able to find them. So let me just end with this to tee this up. I've supported the executive order that President Obama issued last week calling for the closure of Guantanamo in a year, but it is going to be extremely difficult. One, I think there's a sense that the file review of the people who are there is going to be very easy. There is a perception among some groups that if we can only get level-headed people in to Washington to look at all the files of the people who are in Guantanamo, we'll quickly be able to reduce the population from 240 maybe down to about 20, because cooler heads will prevail and we will decide that the rest of these people are just really not so bad after all. I don't think that's going to be what the Obama administration is going to find. They're going to find that there are a lot of bad people left, or that there are people in gray areas. And then finally, with respect to people who they would like to transfer or release, they are going to be equally sensitive, frankly, if not even more sensitive, because of the pressure on them from human rights groups not to return them to countries where they might be mistreated. So if they have an even more difficult time returning them to certain countries like Libya or Tunisia, then they're going to have to find third countries, Europe, to take even more people who can't go back to their home countries. So it's a welcome order to close Guantanamo, but this is going to be an issue that's going to take quite a long time to accomplish.
Steve, let me ask you to follow up on that. There was a mention to placement in third countries. We might say a fourth placement option is this country. Can you comment on the legal aspects of that possibility? There has been litigation on this.
Sure. I mean, let me first join John in thanking you and everybody for coming. There is litigation pending on this question. John mentioned the Weigers, right, Chinese Muslims. In October of 2008, the district court in Washington actually ordered the production of the 17 Weigers at Guantanamo in his courtroom in 3 days. The government did not react too kindly to that request. And indeed, whether Judge Urbina actually has the power to order the release of the detainees into the United States is now before the D.C. Circuit, the Federal Appeals Court in Washington. Legally, here's the problem, right? John mentioned the sort of the tricky side of repatriation, right? That on the one hand, the country may not want them, or equally importantly, international law and United States law may prevent us from sending them back. Right, and the Weigers are, I think, a textbook example of that. The question is, if you can't send them to a third country, right, if there is no other country that will take them that makes sense. So, for example, in the case of the Weigers, there was a long period of time where the administration, I think, was in negotiations with Albania, among other countries. I've never been to Albania, but sounds nice. But the question is, if they can't go there, right, does that mean that they have no remedy? And this is actually a really perplexing question that I kid you not when I say the courts have never really answered one way or the other. Right? So in the immigration context, the Supreme Court has said that the fact that there is nowhere to deport an alien to is not a reason to allow holding them forever. Right? And this is in a case called Zadvitas versus Davis that was actually the Supreme Court's last decision before 9/11. But what's ironic about Zadvitas is in a unfortunately prescient paragraph, Justice Breyer said, of course we are not here concerned with cases of terrorism where there may be other considerations that factor into our analysis. Right, so even though Zadvitas seems to say that as a matter of immigration law, the fact that there's nowhere to send somebody is not a reason why you can hold them forever.
Let me jump in to create more of the conversational dialogue. So one might respond to that and say, well, that would be true if we were talking about admission or this limbo zone for someone whom the government was still claiming was an enemy combatant and so forth. If the government's position is they're not an enemy combatant, does that exempt them from that footnote you just mentioned?
So I think it does. I mean, I think there are plenty of people who would disagree with me. I do think that because the government has now conceded, the government says they are no longer enemy combatants. The district court and the D.C. Circuit have said they never were enemy combatants. Right? And so because it is now established as a matter of law, I do think that brings us within the immigration context. The problem is that in the immigration context, usually you have someone who at least is already in the country physically. Even if not legally, right? And so here the question is, if they're not in the country, if they're at Guantanamo, isn't that different? I think it's factually different, but my own view is that the law for people who are not enemy combatants really should be the same.
I'm going to just spend 1 minute on the Weigers. Actually, let me ask first, how many people know about this group called the Weigers? Show of hands. Most people. Okay. This is perhaps the most intractable group of detainees. The Weigers were largely a group of Chinese ethnicity who clearly came from China, were captured in Afghanistan. It's really not disputable, although Steve can dispute if he does disagree, that they were properly detained, and that everybody's heard about some people who are in the wrong place at the wrong time or pulled out of taxis or things like that. But these people were in training camps in Afghanistan. You can dispute how dangerous they were, whether they were cooks or
although
how much
you would
training
concede
they
that
had.
it wasn't training to wage war against us.
That's just where I'm heading.
Okay.
Is they were there basically because they wanted to wage war against the Chinese. So they were properly detained, and fairly rapidly the military determined, the tragic thing is that they didn't determine it when they were still in Afghanistan, but that they took them in the fog of war to Guantanamo, then fairly rapidly determined that although properly detained, because they were not just cameramen there in Afghanistan, that they didn't pose a threat to us in terms of wanting to fight us. And so since about 2002, we've been trying to send them home. But the Chinese were the only country that said we would like to have them. And we decided fairly rapidly that was not a good place to send them. No other country in the world, except as Steve said, Albania, has been willing to accept them. For 6 years they've been cleared for absolute release. They could walk out the front door if we could find a place to send them. But as Steve said, it's a little different to release someone in the United States who never was in the United States to begin with. And I personally think that probably that is going to have to be what will happen. But it's been a particularly difficult scenario.
I'd just like to add to this that you can tie yourself in knots talking about the Weigers as sort of emblematic of anything at Guantanamo. But the truth of the matter is that the Weigers are an utter anomaly, and they represent almost nothing related to any other group at Guantanamo, I think for sort of three distinct reasons. The first is that the decision to release the Weigers and the pressure to release the Weigers was largely self-generated. The military sort of decided on its own and quite early that it had no interest in holding them. So this wasn't litigation pressure that gave rise to this. The second is that there really is very little chance that they pose any substantial danger. And so there's, you don't have, with most Guantanamo detainees, you have this sort of nagging doubt that there's some likelihood or some possibility or some probability, depending on who the person is, that they're snowing you and that they're actually serious terrorists. And there's one of the guys that we released pretty early who turned out to be a major Taliban commander and then released a video basically saying, "Ha ha, I fooled you." We killed him in 2007. With the Weigers, it really doesn't seem to be that at all. And the third thing is that I think they represent the only case in which the host government, the home government, is not only made very clear, all but publicly, that it will mistreat them, but it has gone around the world threatening other countries with retaliation if they give them safe harbor. So I would just caution against, the Weigers are a completely fascinating story and a fascinating case, but I'm not sure that they stand for anything larger. And there are 17 of them, which is, less than 10% of the current population. It's, significantly less than 10% of the current population. So I just would caution against sort of treating it as emblematic of much more than itself.
Although if John is right about the repatriation difficulty, right? I think one must concede that the Weigers are a factually unique case that you really couldn't make up if you tried, right? But if John is right about the difficulties that any administration, including the current one, is going to have repatriating some of the detainees who have been classified for release, right? Who have been held to be releasable, then I don't know that it's that distinct. The facts are different, right? But the question of whether the federal courts have the power to order the release of a particular detainee, if there's nowhere else to send him into the United States, I think could actually matter in other cases.
I suppose that's right. I suppose it could be the leading edge of a trend. My guess is that the Obama administration will at some point be willing to cut its losses, particularly if it's able to reverse Urbina's decision, to admit them here on a voluntary basis without establishing a precedent is a very, very different
Bobby
proposition.
probably wants to lead us out of the Uyghur morass, but I do think that probably is going to be what's going to happen, because for us as negotiators at the State Department, it is, as we go around the world trying to get people to take Uyghurs or others, but particularly the Uyghurs, the very first question that is thrown back into our face through dozens of negotiations is, well, are you willing to take any? And we have had to say, well, no, we don't want to repatriate any of these people in the United States. And you can imagine the next question is, well, then why should we? I would predict that the Obama administration will, perhaps for humanitarian reasons, but I think frankly just for pragmatic reasons, to take some number in the United States so that they can remove that as an obstacle to the European allies. So I would actually expect that would happen, that they would do it voluntarily. The last point in this, I think, is for the lawyers in the room, is Steve's point is, can a federal judge, does the federal judge actually have the power under the Constitution to order someone who's a foreign national, who never was in the United States, released into the United States? That's really, ordinarily would be a power for the president to control the immigration in and out.
And it has, and just to take that point one step forward, it has the potential for very perverse incentives, in the sense that if you imagine, the situation in which you're contemplating detaining somebody overseas, and you think, well, what if I turn out to be wrong? Does he get to go to Cleveland? And that's a non-trivial consideration that you would create for the Pentagon in situations of captures of people who you frankly don't know who they are.
Unless you don't like Cleveland.
Well, particularly if...
But, I mean, just one final thought on this. I mean, John's right to frame the question. I'll answer. I think the answer is yes, right? I think the Constitution, by giving, where the suspension clause applies, right, where an individual has a right to petition the federal courts for habeas corpus, that right would be meaningless if the courts actually didn't have the power to effectuate that right. Now, that may be why some people argue against Boumediene, but we can have that fight later.
Now, I will indeed lead us out of the morass, as you aptly put it, of the repatriation issue, only to find that I've led us into a second morass. And in this, I think we're getting a sense of exactly what the task forces or force will be grappling with. An alternative, particularly for those whom the administration, upon review of the files, determines do indeed look like dangerous individuals whom they would wish to detain, preferably in our own control. The leading idea here is to prosecute them in federal criminal court, the ordinary federal criminal process. And so I'd like to ask Ben about whether there are, it's often said that that's just not going to work. Why exactly might that be, if that's true, in your view?
Well, I think there's really four distinct reasons why, for any given detainee who you may be completely terrified of, criminal prosecution may not be a viable option. The first is that there's a whole series of conduct that we consider very threatening that is criminal now that may not have been criminal in the fall of 2001. And actually, you're the guy who knows that universe better than anybody.
I'm just asking questions here.
But there's certain categories of material support that are now criminal that were not criminal then, and that probably sweep in a very large number of the detainees. So, for example, foreigners who took training at Al-Farouk or some other Al-Qaeda training facility. This is not unambiguously illegal in the fall of 2001, much less earlier than that. So the second reason is that, and by the way, neither is like being on the other side of a war. Query whether fighting for the Taliban against the Northern Alliance is a criminal offense. I think it is. It's pretty clearly a criminal offense now, but query whether it was then. Secondly, there's all kinds of evidentiary problems. Even for those detainees who you can clearly articulate that you believe they did something that, if you could prove, would be criminal, as the law stood back then. Even entirely, before you get to the coerced evidence stuff, the circumstances in which these people were picked up, it's hard to remember this in retrospect, but the military just wasn't thinking about making criminal cases. That's not what they thought they were doing. And when they were exploring, who these people were and gathering information, they weren't giving the slightest thought to criminal prosecution. And that means you collect evidence in all kinds of ways that won't stand up in court, from not maintaining chains of custody to just collecting information that's very interesting, but is from a legal point of view in a criminal context utterly unimportant. So, for example, if you read the Guantanamo case files, there are repeated references to this detainee's name or alias appeared on a list of captured mujahideen in a safe house that we recovered in a safe house raid in Pakistan. Okay, now that's if you're trying to decide, is this guy dangerous and do you want him walking the street, that's a pretty interesting piece of information. If you're trying to prove a criminal case against him, it's worthless. Third reason is coerced evidence. Some of the evidence, a lot of statements both by people about themselves and by people about other people were the subjects of coercion. Some of it is at a level that we can debate whether or not it was torture. Some of it was at a level that is nowhere near that, but probably wouldn't stand up against a voluntariness inquiry in any self-respecting federal court. And the final issue is that there's a huge amount of this evidence that's just stale. I'm sorry, there's actually an additional issue, which is that quantity of evidence issue. A lot of these guys, if you look at the evidence, if you look at the information that the government claims it has, you would say, scary guy, don't want him walking the street. Is it proof beyond a reasonable doubt? No. Is it even close to proof beyond a reasonable doubt of a criminal offense with each element proven beyond a reasonable? No, it's just not in that ballpark. On the other hand, it is at this level where you'd say, boy, would I be uneasy about him walking the streets. Now, there's a tactical dimension to that, and when you think about releases and prosecutions, and we should be honest about it, a lot of people are not. There's a bunch of these people who, if you let them go tomorrow, they're not going to attack U.S. service personnel realistically because they don't really have a lot of capacity to do that. They're going to attack Afghan civilians, and they're going to attack Iraqi civilians. And so one of the calculations that has been behind the question of manageable risk, right, is who gets killed. And that is, something we don't like to talk about, but the reality is, and I say this principally in criticism not of the prior administration, frankly, but principally in criticism of the human rights groups, that when human rights groups talk about releases, they don't talk about those releases in human rights terms, but those releases have very substantial human rights impact. They're just not human rights impacts on U.S. persons mostly. They're human rights impact on civilians of countries that we don't care quite as much about.
Let me add one thing on the criminal prosecution point. It's interesting. When I started trying to explain Guantanamo to people in Europe, without a doubt, the most commonly asked question that I got, and now it's kind of recycling in our own country as we move in the new administration, is if you think these people did something wrong, why don't you just act like a normal country and try them in your criminal courts? And Europeans would say, we've dealt with terrorism for years in Europe, in Britain, in Germany, in Italy, and we just prosecuted people in these great trials. And what's the matter with you? And we're now seeing this great pressure on the Obama administration to try people. I think Ben did a very good summary of the problems because it is much more problematic. And one, I want to say two things. One, in Europe, and this is really the same thing you see here, is in those cases the terrorists were actually in their countries. They were subject to their laws. The witnesses were in those countries, and the evidence was in those countries. Now, you saw in the one case where that happened here with respect to Moussaoui just how difficult it was to try that case. But in these cases, the Guantanamo cases, all these people were captured outside the United States, often in the hills of Pakistan or Afghanistan. The evidence is outside the United States. The witnesses are outside the United States. So when you hear groups now, and you will, and I've debated some people who say this, well, over the last 8 years we have tried 100 terrorism cases in our federal courts and have obtained convictions, so it proves the system works. That sounds clever, but in every one of those cases, the defendant was in the United States, the witnesses were in the United States, the evidence was in the United States, and the people were subject to U.S. criminal laws. So it really is apples and oranges.
You're counting Abu Ali as one of those cases? Who was in Saudi Arabia, who brings a habeas petition and says, I'm being tortured by the Saudis at the behest of the U.S., who then magically appears in Virginia with an indictment against him?
I think that was probably one of the cases that Ben mentioned after the criminal statutes were changed. I mean, I do think going forward, one of the things that we realized on September 11th, all of our countries, was that our criminal laws didn't have great extraterritorial application. Our legislatures didn't conceive that we needed to criminalize action that took place wholly outside the United States but before a terrorist act had actually occurred. And there's been a great catch-up amongst countries all around the world filling in with our criminal laws. And I do think we should try as many cases in our criminal courts as we can going forward. I don't have a problem with that. I just think that the difficulties that Ben has laid out show, one, with respect to the people in Guantanamo, it's much, much, much harder than people think, if not impossible in most cases. And even going forward, after we have filled in the criminal laws, you've still got these practical difficulties.
I think there's some. Oh, I'm sorry. Go ahead.
I was going to say. I mean, I don't. It's hard to disagree with the practical difficulties. I think in some cases they're overstated, right? So the Moussaoui trial, it's commonly asserted that was an impossible case to bring. The trial judge said it's just like a complicated mob case. Right. I mean, so some of the people who actually did it, disagree.
But again, he was here, witnesses were here,
I agree.
evidence was here, he was arrested by the FBI.
But so this leads to my point, which is I think we have to be careful to distinguish among the different categories that people we're talking about, right? Because I think, it is one thing entirely if we're talking about individuals who are captured literally in the act of undertaking combat operations against the United States on a foreign battlefield versus people who are captured here. And the in-between categories are messy too, right? I mean, someone who is walking down the street, maybe up to no good, but in Sarajevo, right, having, no current connection to the U.S. government, I don't know that you can automatically say we don't have to try him, right? I think the problem is that in some categories, it may actually be true that criminal trial is the only constitutional option. I don't think all categories. I think, certainly battlefield detainees wouldn't fall into that category, right? But I think before we can have generalized conversations about trying everybody, I think we have to be careful to recognize that there are some pretty significant distinctions between the relevant laws that would apply depending on where they were captured, where they're held, and what they're accused of doing.
Yeah, I just want to say my comments about the difficulties were comments in the context of closing Guantanamo. That is, if you take the universe, Steve's point that the universe of people that you're looking at really matters in this context is a very important one. So if you look at the cases, the 120 cases that have been brought successfully litigated in U.S. federal courts, the U.S. federal courts look like a really robust instrument for counterterrorism. But that, of course, is a pre-selected group. That's a group of people pre-selected by prosecutors for the propensity to have fact patterns and evidence that was provable in U.S. courts under the criminal law. If you look at the Guantanamo detainees, which is a very different group, you have a group selected for a totally different set of criteria, which is the belief, however, plausible in a series of individual cases that they posed a threat to the U.S. military based on their identity as combatant members of foreign forces. And that selecting for that is not necessarily going to get you a universe of people that's obviously ripe for criminal prosecution in U.S. courts, particularly as the law stood in 2001.
So one of the things we've established here, if anything, is that there are at least complications for repatriation as an option. There are at least potential significant difficulties for federal criminal prosecution as an option. Although, to be clear, I think we all agree that both of those can be used in many cases and should be used in many cases. If we have any detainees left over, and it sounds like there may be a few at least, perhaps it's a large set, perhaps it's a small set, hopefully it's a null set, but let's assume it's not. What then? I note that the President's order, President Obama's order itself contemplated the need for alternative options, a what then category. Some have suggested national security courts, which is a catch-all term that could mean a lot of different things. Some would say, well, let's have some cleaner, more procedurally pristine form of continuing military detention, perhaps with a narrower definition of who the enemy is, something that's more defensible. And in that regard, they might point to the fact that the habeas review process is now in place, and that has been achieved. I'd like to just go down the row in our dwindling time here to get some thoughts on whether there should be a third option, a third track, and if so, what that might look like. Steve, why don't you start?
So I am very anti-national security court, as you know, and very pro, some new framework statute. I mean, let me sort of briefly explain both of those points. So national security courts mean different things to different people, but they are often thrown about as the miracle solution to the problem of Guantanamo and all things terrorism. Some have proposed national security courts to review the detention decisions, which is interesting since we have district courts who are already doing that. Some have proposed national security courts as a forum where you could have specialized criminal prosecutions of suspected terrorists using procedures that are better suited to some of the evidentiary problems Ben invokes. A better ability to use classified evidence, perhaps relaxed rules concerning the admission of hearsay evidence. The problem is that the proposals for national security courts all presuppose that we've answered the questions that I think are still very much in dispute about who can be detained, about what the relevant standards are. Right? National security courts would just shift the focus of the inquiry. They wouldn't actually change the substance of it. And it's not clear to me that if we actually can arrive at some answer on the substantive questions, why we need a new court.
Let me jump in on that real quick before we continue with that. I just want to make the point that in a lot of these debates about defining who is it that can be detained, we tend to frame this, especially in the law school climate, right, as who does the law allow us to detain under particular authorities. We need to step back first and ask, whom is it in our strategic interest to detain, and how does detention relate to our larger strategic goals? The legal policy needs to be linked up to a clear-headed sense of where we're trying to get to strategically. Then you need to ask, to what extent does the existing legal framework allow you to pursue that particular detention policy?
And that's what bothers me about proposals for national security courts, because they jump over that question, right? Indeed, they jump over both questions. What is good as a matter of policy, and what is actually legal? And they just say, well, whatever the answer is, we'll have a specialized new court that we'll invent out of whole cloth to answer it. And I think that's premature. I do think, this gets me in trouble with some of my friends. I do think the government is well within its right to detain a small class of individuals in a preventive capacity. I would welcome more rigorous procedural safeguards from Congress. I think, right, I don't think any of us are going to object to the notion that Congress hasn't done enough. But I do think that, that is where this heads for the group of people who there's nothing else, to do with.
So as long as they don't call it a national security court.
I don't think you need a new court. I think, the National Security Court is the U.S. District Court for the District of Columbia. And, I don't know why we can't just use that one. And, it's only a 2-block walk from my apartment, so it's convenient for me.
John?
I'm sensing, since I think I know where Ben's going to come from unless he rapidly changes his view, which he may, is that we may actually have an emerging consensus on this point. One of the most difficult legal issues over the last 8 years, and it's going to continue to be a difficult issue for the Obama administration, is what is the legal framework to hold the people who are captured in this conflict with terrorists? So far, as I think most of you know, the people who we have detained in Afghanistan, the Bush administration's legal theory is that they've been enemy combatants in a conflict. And critics love to ridicule the term enemy combatants, and the New York Times puts little quotation marks around it as if the term doesn't actually exist. The legal theory has been that in fighting al-Qaeda and the Taliban, that it really is like a normal war in that regard, where in a normal traditional war you do detain people who are combatants and they're enemy combatants, and no one will dispute in a traditional conflict that part of the president's commander-in-chief authority is that without even additional legislative authority from Congress that he can detain people in a conflict. As people have focused a bit more on the Afghan war, they now concede actually, and some didn't originally, that actually was an armed conflict. That wasn't a police operation. It wasn't the military was in there enforcing criminal laws. So their initial authority, I think almost nobody will dispute, between 2001 and 2002, was to detain people in a conflict under the laws of war. The problem is, as time has gone by, and the detention of these individuals looked like it could go on indefinitely, and people begin to focus on the differences from a normal conflict in that you, one, don't know when this war will end. You know, is Obama going to put up the white flag? Probably not, and there's not going to be a armistice on an aircraft carrier. And two, you can't tell actually even who the combatants are, because in a normal conflict, people wear uniforms and they have IDs, and they want you to know, generally, except for a few spies here or there, that they're combatants. And the difficulty in this case has been how to fit these people into the traditional laws of war or not. So the Bush administration's theory has been to continue to hold people as enemy combatants, but that has become understandably troubling to people. The criminal model to say, well, you can only hold people if you can try them, we have discussed a bit. And we also do have to think in any changes that the Obama administration will make with respect to the people in Guantanamo, well, what would be the legal theory for people detained in the future? We've got 100,000 or more troops around the world capturing terrorists. And if the message to them is that your only legal basis to hold somebody is if you can bring them back and try them in a court, well, the military will probably resign en masse because they don't think that they are out there just enforcing the criminal laws. So Steve's right, and this is what's difficult about it, is that we're probably going to need to have a sort of a varied approach that people can be initially detained under the laws of war, but because this is a different kind of war, then there need to be additional review mechanisms. I have long supported, and I think this is what more people are looking at, but it remains controversial as well, is going back to Congress to seek legislative authority to detain a category of people so that you're not just hanging it on the president's commander-in-chief authority to hold people indefinitely on the president's say-so, and have Congress set up an administrative detention regime that says these people may be detained for X period of time subject to certain review by a federal courts. Now, critics have called that preventive detention, and they don't like it because it seems to be holding people indefinitely without trying them. But the alternative is either just letting dangerous people go or holding them as enemy combatants, which people also don't like. So as with much in government, it may not be a perfect solution, but it may be better than the just relying on the enemy combatant model. So the National Security Court is a term that's used for a, well, as Bobby said, it means different things to different people, but it could be a court that is used to review those who are detained pursuant to legislative authority provided by Congress, so that a court is actually periodically reviewing the individuals who are detained and putting essentially the government through their paces to show that someone is dangerous. So bottom line, we really have to work hard on what is going forward on the legal basis for detention. This is perhaps the trickiest issue of all. The Obama administration will have a very difficult time. I personally support going back to Congress and getting administrative detention authority.
Well, I find myself in an awkward position here because Steve started, and we've done these panels before, and we've always had this sort of same exchange in which he articulates very strong opposition to the idea of a national security court. I support the idea of a national security court, and yet we have trouble figuring out exactly what it is that we disagree about. So Steve, I'm just going to vamp a little bit off of what Steve said, which is, so he opposes a national security court because we amongst other things, we already have one. It's the U.S. District Court for the District of Columbia. I was going to use that line. The truth.
I borrowed it from our last panel.
Yeah. The other thing that he said is that he supports a framework statute to regulate detentions. So here's the common ground, and John's well within the common ground. The common ground is that we all agree that there is some, we suspect, residual category of detainees that you're not going to be able to send home and you're not going to be able to prosecute, and you're going to have to continue to detain outside of the criminal justice system, number one. Number two, we all agree that that detention will be supervised in one way or another by the federal courts. Now, we actually all agreed, even before Boumediene required that as a matter of constitutional law, we all agreed on that point as well. So that was a point of common ground. And third, we agree that it is suboptimal for the executive to be litigating in front of the federal courts based on current detention law, that is to say enemy combatant detentions. We want to see a framework statute that answers some of the really hard questions that are currently being decided in these habeas cases on a sort of an ad hoc basis. So I think the nomenclature question, whether you call what results from that a national security court or something else, a framework statute, for example, is of almost no importance whatsoever next to the areas of agreement. Now, I do think, that said, that there are a few advantages to thinking about the framework statute ambitiously rather than narrowly. You can think about it narrowly. Let's just define the universe of people who call them real enemy combatants or whatever, who you really don't want to let go. If they're not within that definition and they fall within some common law of war definition, we might be willing to see them go. That's one possible framework statute. My idea of what a framework statute should look like, and I think you'll see why I'm more comfortable with the idea of calling it a national security court than Steve is that we really should be drawing on bodies of law that are broader and more diverse than the laws of war. And one of them that I find sort of particularly compelling in this area is the law of mental illness, where importantly, right now under Boumediene, if you're an enemy combatant, you litigate your habeas case, and then Judge Leon says, well, in this case, you're rightly detained. You appeal that up the appellate ladder, and then it's over. There's no sort of continuing obligation on the part of the government to show that you still need to be detained 5 years later, right? You were rightly categorized, and that's the end of the ball game. Now, the paranoid schizophrenic, though he has a much more intractable condition, has a much better legal framework, frankly. In his case, the government has to go to the court prospectively, ask for permission to detain him. Once having done that, the court retains jurisdiction over that detention for as long as it persists. I think that's a much better way to think about administrative detention or non-criminal detention than we pick you up and you file your habeas case, we resist your habeas case, we win, you're out of luck. Some continuing obligation where his lawyers can come forward and say, okay, 5 years ago he was a really scary guy, but actually, he's discovered the works of Gandhi at Guantanamo or wherever we're going to hold people now.
It's Rod Blagojevich we're talking about?
There were a lot of people at Guantanamo who the government made a judgment are not so dangerous anymore that we need to continue to hold them. And if you believe those judgments too have to be defended, particularly when they're adverse to the detainee, that's an argument for a prospective and more pervasive involvement than a light tinkering with the current system would give you. And so once you create that, you start looking a little bit more like it could be, again, I agree, you could make it a specialized set of procedures in U.S. District Court and for the District of Columbia, and I'd happily call that satisfying the national security court vision that I've, generally supported. But the major point is that I think you need to think ambitiously about what the procedures here are going to look like, and we need to be, we need to get out of that box of is he an enemy combatant or not, and that's a sort of binary judgment.
I don't disagree. I mean, shockingly, I don't disagree with that. But there's one important point that I think Ben's omitting, and it's because Ben is not one of the proponents of national security courts who believes this. There are a number of people who support national security courts who emphasize that two of the hallmarks of their proposed court would be the ability to take evidence that is not usually admissible in normal civilian judicial proceedings, and the ability to do things in secret, perhaps without the subject of the proceeding even present. Right? Now, the problem is that I agree with Ben wholeheartedly that with the proper framework statute, with a thoughtful and detailed procedural regime, there's no reason why the federal courts as currently constituted couldn't do all of this. Right? But when you create a different system with lesser rules, and before you've solved who would even be subject to the system, I think you're opening the door to a lot of trouble. I mean, I think, who's going to decide whether you go to a national security court or not? Right? I mean, I think the more we can regularize what we're doing, the more we can actually say there are other areas of society where we have analogous procedures. Right? Let's import those. The more this does not just look like a special and second-class system of justice that we've created just because of a problem that is at least partially our responsibility, I think the less people like me and people who work for human rights groups are going to shout about it.
Before we turn to questions, because there'll be many, I feel I've probably got to say one thing. We've mostly been talking about, in fact, exclusively been talking about domestic law, the domestic law authority to hold people, and I think all of us do agree that we should go back to Congress, who have been, frankly, woefully absent to get some legislation that would specify who may be detained. Part of closing Guantanamo will almost certainly require legislation, not because the president can't just move people to the United States on his own, but because we'll have to clarify the legal authority for holding them here. And then there will be a battle royal in Congress as to what that's going to look like. So watch for that this year. I have to, though, say, as the now former legal advisor at the State Department, I have to say something about international law, which is what's the international law basis to hold people? We haven't mentioned the Geneva Conventions. In an armed conflict, a customary international law does say you can hold combatants who are fighting you in an armed conflict until the end of the conflict, and that's just sort of black letter international law. The debate then gets to be, well, when is the conflict like this actually over, and what treaties apply? And as you all know, there's been a great debate about whether the Geneva Conventions applied, and President Bush concluded in February 2002 that the Geneva Conventions, and particularly the Third Geneva Convention, which covers prisoners of war, don't apply to the al-Qaeda and Taliban detainees. And that's been much criticized. As a matter of law, though, much of that, at least, is correct. The Geneva Conventions apply to conflicts between high contracting parties. They are essentially, it's a treaty, it's a contract amongst the countries that have signed up to it, and they say, if we get into conflicts with each other and capture each other's people, this is how we are going to treat each other. Al-Qaeda represents a whole lot of different, in fact, they don't represent anybody. They don't represent different countries. They come from different countries. But the conflict with Al-Qaeda was not a conflict between the United States and a contracting party to the Geneva Convention. So the members of Al-Qaeda could not qualify for prisoner of war status. Probably a much closer call with respect to the Taliban, who did represent the government of Afghanistan, and that's been much debated. But going forward, in the Hamdan decision, which Steve litigated, the Supreme Court accepted that the Geneva Conventions in their totality did not apply to Al-Qaeda and the Taliban, so that the individuals were not entitled to prisoner of war status, but they did conclude that an important provision called Common Article 3 which is common to all of the Geneva Conventions. It's the exact same provision in all the Geneva Conventions, and which sets basic standards of humane treatment for anyone, is what the detainees in Guantanamo are entitled to. One of the issues for the Obama administration will be to determine, in addition to what domestic law authority the President holds either the Guantanamo detainees or people captured in the future under, what the international law framework will be. Do we determine that the Geneva Conventions, more of the Geneva Conventions apply? There's a fourth Geneva Convention which covers civilians who are captured in armed conflict. I think most people generally believe that has to do with civilians who are minding their own business who are captured in an armed conflict, and not civilians who are fighting you in an armed conflict. But there's a reasonable argument that this fourth Geneva Convention could be an international law framework that would cover the detainees, so that we get out of this allegation that we've put the detainees in a legal black hole. So that's a complicated area, but I feel I have to mention the international law framework as well as the domestic law framework.
Let me jump in on that, and then we'll switch to questions. Just following up on the fourth Geneva question, I'm glad you raised it because it so rarely gets talked about, and it's as important to this debate as third Geneva. On one hand, I'm not sure I would agree that the fourth Geneva framework doesn't contemplate the civilian who's the security threat, including the armed security threat. On the other hand, what often gets overlooked is that fourth Geneva does, by its own terms, exclude from its protections those who are nationals of countries with ordinary diplomatic relations with the detaining power. And in an unorthodox scenario like a non-state actor, transnational entity like Al-Qaeda, you've got a bunch of nationals of our allies or other states. This is an area where changing circumstances and how war is fought and the change in the emergence of non-state actors as a strategic threat does expose some lack of planning and foresight in the international armed conflict rule framework, let alone in the non-international armed conflict rule framework. And there is a need for further thinking on this. I'm going to move to the podium in just a moment, and we'll begin taking questions. But first, I can't resist a lightning round. So if you will indulge me, I really wanted to...
Is there music?
Only... if this weren't being filmed and recorded, I would do something, but alas. As I mentioned earlier, Judge Bates has before him the question of whether Boumediene should be extended to Bagram Air Base. Going forward, this is in some senses a much more important question, the status of these rules and judicial oversight as to Bagram than Guantanamo. Guantanamo is sort of like the Patriot Act in that it's got this iconic value and it sucks all the oxygen out of the debate and consumes it itself. There are other issues that are bigger questions going forward, not to belittle the incredible diplomatic damage that the idea of Guantanamo does. Once we get past that, somehow we get past it, these debates we've been having about the detention framework going forward, to some extent, are connected up with this question of judicial review. So, lightning round style, but with freedom to elaborate briefly, how should Judge Bates rule? Steve?
I'm going first. You'll be shocked to hear that I think Judge Bates should say that there is jurisdiction over Bagram, right? That the federal courts have the power to hear habeas petitions filed by non-citizens detained at Bagram. But I do think most of them will lose on the merits and will lose fairly quickly. I mean, as a sort of federal courts geek, I think we've actually spent way too much of the last 6 years forgetting the distinction between the fact that you get to go to court and file a piece of paper versus whether you actually win. And so I think the answer to the jurisdictional question is yes. I think the answer to the substantive question is tricky and depends on what we've been talking about.
Intermediate question. Right to counsel, right to discovery. You can phone a friend.
I was going to say, do I have a lifeline?
Yes.
I think that would, I'll jump in. I think that would be an extraordinary thing if the detainees in Bagram, who clearly are in a war zone with a hot war going on around them, even if Bagram itself is relatively secure and under U.S. control, and people who have no connection with the United States, never been in the United States, are then able to file habeas cases in the United States. And Bobby asked the right questions. That if you go there, then do they get lawyers? How can they present a case if they can't get the evidence against them? So here you have an Afghan who's been caught on the roads planting an IED and is the next thing he is litigating his case in the United States courts. It's the Supreme Court in Boumediene did leave the door open in finding that constitutional habeas applied to Guantanamo because of our degree of control over Guantanamo, left the door open that could possibly apply in other places where we have similar control. And the Europeans, interestingly, are finding exactly these same problems. The European Convention on Human Rights does extend to any place where European soldiers are essentially exercising control, and they are now finding themselves absolutely bedeviled by this because if they capture someone in Iraq or Afghanistan, or if they simply just capture a pirate, one of the big problems we're now finding with pirates off of Somalia is if Europeans pick up a pirate, the next thing you know, that pirate is litigating a human rights case in Copenhagen, and what it's resulted in is at least the Europeans, and I think this would be frankly the pragmatic concern, maybe in addition to legal concern, is that if our European soldiers or our soldiers in a foreign country are finding that anybody they capture suddenly has a whole panoply of legal rights in a country that they've never been to, it will frankly create probably perverse incentives for the military either to kill people rather than detaining them. So, or just not to detain people who ought to be detained.
But I mean, there are two responses to that, right? The first is I think counsel and discovery goes to whether they have substantive rights on the merits, right? Which I think does turn on the circumstances of their capture, right? So, someone who is caught by our military planting an IED, I think that's an easy case, right? But I do have to say, I think we have to step back and look at this as how it's framed. Right, what John is saying is that we have to worry about the problem of giving rights to people who are not in the country and who have no connection to the country. Query whether the fact that they're in our custody means they actually have a connection to our country. But it's odd, right? Because the founders would have said, ours is a government of limited powers, right? And so I think, we've completely conflated the question in the war on terrorism. Now we ask, not whether the government has the power to do something, but whether there's any reason why they can't. And I think now, that's not to say that there aren't hard cases, right? But I do think we have to be careful to distinguish between the power of the courts to decide these hard cases, which is the jurisdictional question in Makala.
For my common law question, students here in the room, you detect that Steve is not a fan of Justice Sutherland's opinion in Curtis Wright, no?
Yeah. Neither is the current Supreme Court. But my point is just, I'll put this quite simply. It is not because I think someone who plants an IED in Afghanistan has a right to counsel and a right to discovery, or even that we should be particularly sensitive to protecting his rights in our courts. It's because we don't know the difference between that guy and the guy who is randomly picked up by accident who has, false identity until some neutral decision maker has the chance to say so, right? And there are just too many mistakes to actually suggest that we can't have somebody overseeing all of this.
Yeah, I actually also think that in the long run, habeas jurisdiction over Bagram and everywhere else in the world is all but an inevitability. I think if the court had not wanted to do that, there were 100 ways to write Boumediene that were more dependent than the way that Justice Kennedy wrote Boumediene on the jurisdictional status of Guantanamo, which is actually unique. And you could have pegged the decision to that unique status, and the court made a very deliberate decision not to do that. And in the long run, what that means is you're going to get people held in all kinds of locations all over the world who are different from the people at Guantanamo only by virtue of their being there rather than at Guantanamo. And the question then will necessarily arise, as it is now in Judge Bates's courtroom, hang on, if I were at Guantanamo, you'd have jurisdiction. What's the difference if I'm here? And the answer, that's not a stable line, and it won't hold. And so I think, one of the reasons that I believed Boumediene should not come out the way it did come out, and one of the reasons I wrote in criticism of it both before it happened and after, is that I think it does create a situation in which you end up on a road to habeas jurisdiction following the military wherever it goes around the world. And I think that is actually a maladaptive rule that creates very strange incentives, and one of them is the incentive to the Predator drone.
One final thought. I'll note that Judge Bates, in his review of this question we've just been grappling with, asked the government to produce to him a list of where the detainees at Bagram were captured. Were they captured in country? That is, within the battle zone that John's describing. Were they captured out of the country and then brought to Bagram? And it'll be interesting to see if that distinction, which in a conventional armed conflict setting, that locus of capture question wouldn't be particularly relevant, see ex parte Kieran and others, may become highly relevant as simply a way to try to cut the Gordian knot in this context. We shall see. You guys have been awfully patient, so without further ado, I'd love to start taking questions from the audience. We have Braden has got the mic. Braden, why don't you come forward with the mic, and we'll start with this gentleman and then go to the woman on the aisle there.
Good afternoon. Thank you for being here. Question is, given the sort of Gordian knot that you've been talking about, and further that there's also a conflict of law rule as to whether U.S. law would apply in Afghanistan or Iraq or Somalia, or the host country law would apply. Would another approach be, rather than looking at changing, augmenting U.S. law, be to pursue a fifth Geneva Convention through the auspices of UN or other body to address these issues so that in future engagements, armed forces, whether NATO, U.S., Russian, etc., would know prospectively going in what the rules would be?
Let me take a stab at that, in large part because this is what I've personally been spending the last 4 years sort of trying to do. I think the short answer to the question is, because a lot of people have asked that, when they listen to all of this and they say, in general, gee, this actually is harder than I thought. Here's what's happened in Europe when all my discussions with the Europeans. They go in thinking, the law was very clear, we've completely screwed this up, and after a lot of discussion they realize this is actually a lot harder than we thought. We're not comfortable with what the U.S. has done, but we concede that it is, in fact, as you say, a legal Gordian knot. And then they say, well, how about a fifth Geneva Convention? In concept, I think that we do probably need something like that, but we need to walk before we can run. It's extraordinarily difficult to negotiate a multilateral convention with 190 countries. It would take decades, and particularly in a controversial area like this. What I think we do need to do, though, is, and what I have been trying to do, is to persuade people that, in fact, there are some lack of clarity in the law with respect to conflicts with non-state actors, that the Geneva Conventions don't fit them perfectly. As Bobby said, you can shoehorn people into the Geneva Conventions, and maybe we ought to try to do that, but they were really designed for different kinds of conflicts. The criminal laws were designed for people who basically committed crimes here. The Geneva Conventions were basically designed for conflicts between standing armies. So what we should do is try to get countries who are seeing these difficulties and who need to balance law and the need for law with practicality to first identify the problems, then identify certain principles. We want people to be treated fairly in some way, and then sort of agree on some principles which could then perhaps expand ultimately into a new convention. But it would be hard to just sort of start 6 months from now and say, we agree there's a problem, let's negotiate a new convention. But I mean, I agree with the basic point you're making. There is a lack of clarity in the law. Countries need to get together to try to agree on where the problems are and what the rules ought to be.
There is of course one other possibility. If I wasn't in enough trouble already, there is at least some discussion in the international community, including Europe, about the role of the International Criminal Court. And the notion that terrorism, because it raises particular sort of quasi-domestic and international problems, might actually be a particularly apt thing for the International Criminal Court to focus on. That begs the question of what is terrorism.
I mean, it helps with prosecution.
Right. It doesn't help with detention.
But it doesn't help with detention.
One of the other, just very briefly, I also agree that, in theory and principle, what you're talking about is the end point. There's a particular negative incentive from the U.S. point of view, which is that there's this transatlantic gulf over, IHL to some degree. And, the last time we reopened the Geneva Conventions, we got Protocol 1, which we couldn't, submit for ratification. And, so I think there is just sort of some measure of doubt that if you do that, you would end up with something that was better for you than the current status quo.
Thanks for a very interesting discussion. My question is about these people who sort of have no options, people who should be releasable but they don't have anywhere to go. And I was wondering, generally, like you pointed out, with immigration status, you have to be in the country to be able to get this done. But of course, the exception to that is like asylum status or refugee status. And I'm wondering if that's an option. My understanding is that some people have been pursuing asylum petitions. And, arguably they haven't had an association, or their association with the U.S. is an involuntary association. But, is it all that different from, like, say, somebody who translates for us in Iraq or Vietnam, and their life is wrecked if they stay there, so they've got to get in?
I think asylum is a helpful way of thinking about it. There's one factual distinction that I don't think is that important, but I think other people do, which is even asylees are usually asking for asylum at the border, right? So they may not be legally in the country, but they may at least be physically in the country. Of course, in immigration law, this is known as the entry fiction. It is true, though, that, I think, when you hear, when the counter-arguments are made by the government, and it'll be interesting to see if the Obama administration continues to push this, that the federal courts lack the power to admit these people into the United States. I think, immigration law is certainly where the precedents are. And there's actually plenty of precedents for temporarily paroling certain classes of people into the country. I spent 2 years teaching in Miami. The Marielito Cubans, right, are actually an example we've completely forgotten about. People who were never legally in the country, but who we just said, come on in and we will pretend you're not here.
I actually think the concept of asylum, with the solitary exception of the Weigers and a few isolated other people, has virtually no application in this context. The reason is quite simply that when you talk about giving somebody asylum, you're generally not talking about somebody who you're mentally assessing the possibility that they'll do something awful. You're talking about people that you think are victims, right? And you're protecting them. Now here the calculation, again, with a certain set of people accepted, is very different. It's, we believe these people are military enemies of the United States. Remember, almost all these people carry the designation enemy combatant, and the government has not backed off of it. We believe that the danger that they pose, we presuppose that there is a danger, and that but we've made the judgment that the danger that they pose can be managed by some means other than detention. And like every other process in this crazy thing, we know there's an error rate. So to talk about this in the language of asylum is really to subject the domestic U.S. population to exposure to that error rate, whatever it is. And it's a very different calculation, because you know you're going to be wrong a certain percentage of the time, right? And you can measure that percentage. It's somewhere, if you believe the military, it's somewhere around 60 out of 500 people, right? If you at least 60, right? If you don't believe the military, you think they're inflating it, maybe it's around 30 or something. So somewhere between 5 and somewhere over 10% of the time, you're wrong. And when you're wrong, you may be really wrong. And so the question is whether you want to be really wrong here or somewhere else. And I think that's a question that's very different from the question of, how generous do you want to be in protecting people from tyrannical governments? Now, granted, this one interlaces those two questions, but I don't think asylum is the concept that's going to be the operative concept here.
Right next to you there, Braden.
What are the limits on the power of the United States or any other country to criminalize behavior that occurs outside its borders? What's the legal basis for that limitation?
That's an interesting question. And it's also an interesting question for other countries. As I said, before 9/11, we really had not criminalized a lot of conduct that occurred solely outside our borders, particularly preparatory conduct, and similarly with other countries. And there are now great debates going on in other countries about the extent to which they can criminalize conduct outside. I might turn to Steve on the constitutional question. I think in large part we have done a lot of catch-up since 9/11 by extending the reach of our criminal laws to material support, to purely preparatory acts, to stretch it pretty far. So I think we now can cover a lot of actions, including exclusively by foreign nationals that occur wholly outside our country before there's even been an attack or even necessarily a conspiracy. I'll mention one example not involving our country, which I find kind of interesting, and invite Steve on the constitutional point. There's been, as I am told, a great debate in Germany about the extent to which they can criminalize even a German national coming from Germany to go to train in a training camp in Afghanistan and then come back if they can't actually show an intent or an action to attack Germany on the theory that the person is simply expressing himself by, it's essentially sort of a version of free speech, although they don't have a First Amendment in that regard, but that the Germans who simply go to a training camp could not be criminalized simply for doing that. In our country, absolutely, an American who goes to train abroad would be subject to the jurisdiction of our criminal laws.
I mean, it probably won't surprise you to know that the body of law is a bit of a mess. Right? So in international criminal law, there's actually a substantial debate about the different bases for exercising jurisdiction. Right? There's something called the passive personality principle, which is very controversial among international law people. The constitutional law issues have really never been fleshed out because, as John says, it has not long been our practice. Perhaps the best example of a pre-9/11 statute that actually contemplated extraterritorial criminal jurisdiction was the Military Extraterritorial Jurisdiction Act, which was passed in 2000. It's not exactly that much long before it. I think if we actually go back to constitutional law first principles, right, Congress only has the power to criminalize things that fall within its power to regulate. Right, so we actually have to ask the Article 1, Section 8 question. And under Article 1, Section 8, Congress, most of the federal criminal offenses in the criminal code are tied to Congress's commerce power. I think it would be hard to suggest that someone training overseas to injure another country is interfering with our commerce. But Congress also has the power to define and punish offenses against the laws of nations. And that's actually oftentimes where the power to punish these kinds of offenses comes from. But of course, that begs the question of what the laws of nations actually prohibit. Right? So in a way, this all ends up being circular. And I think one of the questions that we'll never actually get to answer about the Military Commissions Act is whether it actually transgresses some of those constitutional limits with regard to some of the offenses that the commissions are given jurisdiction over.
I have to jump in with a follow-up question. If Congress has the textual power to define and punish, can a court reject their definition of something as being a law of nations violation?
So Bobby knows I'm starting to work on a paper about this. I say starting to because I haven't answered that question yet. It's funny. If you start from the proposition that Congress cannot define shoplifting as an offense against the law of nations, which I think is a fairly uncontroversial proposition.
Is it?
Okay, maybe it's not.
This is law school.
Let me put it this way: if Congress's power to define offenses against the law of nations was plenary, then it would render the Commerce Clause unnecessary for criminal law, right? That Congress could actually codify any criminal offense it wanted simply by calling it an offense against the law of nations. Somehow, I think people will not find that argument particularly compelling. The question becomes, what is the outer limit on Congress's defined power, right? And I think, the answer is probably some reasonable interpretation of the current state of international law.
Further questions? This fellow in the blue T-shirt there.
You've all talked about the procedural problems inherent in effecting some kind of review of the status of the detainees we're currently holding, but you've only brushed on the problems of detention, and you suggested that there should be some kind of 5-yearly check-in to see if they've been reading their Gandhi or something. But what kind of responsibility do we have to provide detention facilities and procedures? I know the current administration is looking at moving detainees to Camp Pendleton or Fort Leavenworth, but there's been a lot of objection raised by the military and by local communities. So how long can we hold them for, and what should we be doing with them while we're holding them?
I think the short answer to that question is how long can you hold them for is, under the laws of war, you can hold them till the end of hostilities, which is a hard concept even to imagine in this context, particularly because if you held them till you declared the end of hostilities and you had the right guys, and then you said, well, we've declared the end of hostilities, so now we release you, you would reinitiate the hostilities by virtue of the release, which gives you some sense of the mismatch between the detention authority that we're using and the detention authority that would be relevant and appropriate to this situation. So the hardest question to me is, I think there's a group of people there who, and frankly who I envision that we might catch in the future, I hope we will catch in the future, who the answer to that question is, I don't envision ever letting them go. And in exactly the same way that I don't envision letting the paranoid schizophrenic who shot up the Capitol, I don't think he'll ever be ready for trial. And I'm content to, not content, but I just don't see that there's an alternative to, continued indefinite non-criminal detention for that group of people, subject to a pretty rigorous regime. On the conditions of confinement stuff, my basic attitude toward it is it should be required as a matter of policy, if not as a matter of law, to be, given that it's non-punitive, supposedly non-punitive in nature, to be as non-punitive as possible, consistent with the necessities created by this very difficult population. Now, the experience of Guantanamo is pretty instructive there, and it's unfortunate, actually. It's not, I can't give you good news, So the military had this great idea, which was to build like a really nice, kind of, I don't quite know how to describe Camp 4 at Guantanamo. It's kind of like a Hogan's Hero kind of POW camp, So if you imagine your sort of prototypical POW camp, Camp 4 is kind of it. There are very few detainees in it. And if you talk to the military guys down at Guantanamo, they say it's the most dangerous place in the facility at Guantanamo. There have been riots there. There have been, serious problems. And the reason is that, at least some large percentage of this population really, really doesn't like us and really wants to, create problems in whatever way they can. And that does make the conditions of confinement problem hard. But I think the principle is, you're not trying to punish people in these detention with this sort of detention. You're trying to prevent them from doing terrible things, and you want to do that in, it sounds perverse to say, as gentle a way as you can.
We are short on time, so let me conclude with one further thought and then some thanks and acknowledgments. The thought is that at the end of the day, even if we're able to construct a new detention regime or set of detention policies that strikes a better balance than what has gone before, one of the wild cards in this process will be, how is it perceived? And this is an abstract, difficult question to get our minds around. How is it perceived domestically? How is it perceived internationally? We can't ignore these things, because if it's not perceived to be legitimate domestically by a substantial enough part of the population, then it won't be sustainable, no matter how much sense it might make in a seminar room. And if it's not perceived with some requisite degree of legitimacy on the international sphere, our allies and the many communities upon which we depend for cooperation, we're going to lose their support to some degree as well, and we can't lose our focus on that. So I think if there's one thing we can take away from tonight's discussion is that it's understandable why the administration would like to have at least 6 months to continue to work through this, and unfortunately, they simply don't have that time. So if nothing else, it will keep the legal academics and others who comment on this stuff in full employment. I want to thank Braden Sivens, who's been handling the microphone, Debbie Van Loan, who handled the arrangements for our guests, Laura Castro and Kirsten Fortune and Maria Allen, who were indispensable in arranging the larger logistics of this. And I want to thank all of you for your patience and kindness. Please stick around as we adjourn into the atrium next door. There should be some refreshments out there, and we'll linger as long as we can. Thank you and good night.